The third pertinent issue before this honorable court is whether the custody of the child to his mother will be detrimental to his physical and mental welfare, and whether the financial condition of the mother is to be considered while giving over the custody of the child. Your Lordship, it is humbly submitted before this honorable court that the custody of the child to his mother will be detrimental to his physical and mental welfare. The custody of the child is linked with the guardianship. Your Lordship, Section 6 of the Hindu Minority and Guardianship Act 1956 provides that the meaning of the natural guardian and the act doesn't include the words stepfather and stepmother. Thus, they are not the natural guardian of the minor child. Therefore, Your Lordship, it is clear that the stepfather will not be beneficial to the minor child because the respondent has remarried to another person and thus guardianship can be terminated on this ground. Your Lordship, further it is stated in Section 39 of the Guardians and Wards Act 1890 that the court may, on the application of any person interested or of its own motion, remove a guardian appointed or declared by the court on the following causes, that is, for abuse of his trust, for incapacity and ill treatment, etc. Your Lordship, in this instant case, the respondent has submitted to the Udalguri Family Court that she would not remarry, but after the judgment of Udalguri Family Court, she has remarried to another person. Thus, she can be removed from guardianship as she has abused his trust under Section 39A of Guardians and Wards Act 1890. Therefore, the custody of the child should be given to the father. Your Lordship, Section 17 of the Guardians and Wards Act 1890 further state that the character and incapacity of the proposed guardian should be observed. Your Lordship, the well-being of the child in care of the mother was found to be mischievous as he was twice caught stealing his classmates' personal belongings. Your Lordship, here we want to draw the attention of this honorable court of the case of Rosie Jacob versus Jacob A. Chakramangal, where it was held that the children are not mere chattels nor they mere playthings for their parents. Absolute right of parents over the destinies and the lives of their children has in the modern change of social conditions yielded to the consideration of their welfare as human beings so that they may grow up in a normal balanced manner to be useful members of the society, and the guardian court in case of a dispute between the mother and father is expected to strike a just and proper balance between the requirements of welfare of the minor children and the rights of their respective parents over them. Your Lordship, material welfare of the child also includes provision for a pleasant home, standard living and good health, etc., which will not be possible if the custody is given to the mother as she is financially not stable as the father. And even she is remarried, which will hamper the child's overall development because the child will not be able to cope up with his stepfather, and if in future any child born out of their wedlock, this will compromise the interest of the child. If your Lordship are satisfied with issue number 3, the Council seeks permission to proceed with issue number 4.
Council, if the court decides to terminate the guardianship is given to the mother and hand over the guardianship to the father, so under which section of the Hindu Minority and the Guardianship Act is the court allowed to do so?
Your Lordship, the guardianship can be terminated under Section 13 of Hindu Minority and Guardianship Act. Much obliged, Your Lordship. If Your Ladyship are satisfied with answer, the Council seeks permission to proceed with issue number 4. Much obliged, Your Lordship. Your Lordship, the issue number 4 is that the act of husband accusation of unchastity actually amounts to cruelty. Your Lordship, it is humbly submitted before this honorable court that the actions of the petitioner considered separately do not amount to cruelty, and hence divorce on the same ground reflects gross injustice toward the petitioner. Your Lordship, further Section 13 of Hindu Marriage Act 1955 state the ground of divorce. Any marriage solemnized whether before or after the commencement of this act may on a petition presented by either the husband or the wife be dissolved by a decree of divorce on the ground that the other party has, after the solemnization of marriage, had voluntarily sexual intercourse with any other person than his or her spouse, has, after the solemnization of marriage, treated the petitioner with cruelty, or has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petitioner. Your Lordship, in this instant case, the respondent has falsely charged of accusation of unchastity against the petitioner. As the petitioner was a businessman and he resides in America, and also he kept visiting his child as well as he provide maintenance for both. The petitioner did not commit any form of cruelty on the respondent. Your Lordship, cruelty in matrimonial law may be infinite variety. It may be subtle or brutal. It may be physical or mental. However, the respondent did not mention what type of cruelty was committed by the petitioner, and she did not have the proper grounds of cruelty by the petitioner. Your Lordship, further in several cases it has been held that provocation is still a good defense to charge of cruelty. Your Lordship, in Jamieson versus Jamieson, it was observed that every act must be judged in relation to spouse's temperament. Acts which appear on the face to be unpardonable may in particular circumstances be, if not justified, at least excused by the petitioner's own conduct and the amount of provocation he or she has offered to the respondent. Your Lordship, further in the case of Parveen Mehta versus Indrajit Mehta, it was held that in case of mental cruelty, it will not be a correct approach to take an instance of misbehavior in isolation and pose the question whether such behavior is sufficient by itself to cause mental cruelty. If your Lordship are satisfied with issue number 3 and issue number 4, the Council seeks permission to proceed with the prayer. Much obliged, your Lordship.
It's a minor child. According to you, he can make his own guardianship in which act it is provided. Is it possible to make?
Indeed, your Lordship, if a minor is able enough to make a choice, then under section 17 clause 3 of Guardianship 1 Awards Act 1890, he can make his own choice. Much obliged, your Lordship. If your Lordship, if you are satisfied with the answer, the Council seeks permission to proceed with the prayer. Much obliged, your Lordship. Wherefore it is prayed, in light of the issues raised, advanced arguments and authorities cited, that this Honourable High Court may be pleased to adjudge and declare that the appeal filed by the petitioner is maintainable. The decision of the subordinate court is dismissing the petition for restitution of conjugal right is not valid. The act of the petitioner does not amount to cruelty. The custody of the child should be given to the petitioner, and pass any other order it may be deemed fit in the interest of justice, equity and good conscience. For this act of kindness, the petitioner as in duty bound shall ever pray. It was pleasure arguing before the Honourable Court. Much obliged, your Lordship.